Hi everyone, thanks so much for coming, and thank you to our co-sponsors, the Plant Forward Yaleys, the Yale Animal Law Society, and the Yale Environmental Law Association. This event is being recorded, and all the food in the back is vegan, and so Professor Jacewicz will take some Q&As after her talk, so if you could hold all questions until the Q&A portion. And so I'm so excited to introduce Natalie Jacewicz today. She is an assistant professor of environmental law at the University of San Diego School of Law. Prior to USC, Professor Jacewicz was a Furman Academic Fellow at the NYU School of Law and a clerk for the Honorable Judge Randolph Moss of the U.S. District Court for the District of Columbia and the Honorable Judge David Tatel of the D.C. Circuit. Professor Jacewicz is a rising star in environmental and animal law. Her work tackles urgent questions around humans and the law's relationship to the environment and animals, and has appeared or is forthcoming in the California Law Review, NYU Law Review, Harvard Environmental Law Review, and the Michigan Journal of Environmental and Administrative Law. And so the work she'll be presenting today addresses some of those urgent issues. Wild animal abundance is plummeting, and yet American law largely fails to protect animals who are considered common. And so this neglect is unacceptable, but as Natalie argues, is also rectifiable. So please join me in welcoming Professor Jacewicz to Yale Law School.
Okay, well, thank you so much for having me. As just stated, I'm Natalie Jacewicz. I'm an assistant professor of environmental law at University of San Diego School of Law, and I'm going to be talking to you about protecting wild animal abundance. This is a work in progress. Like an amphibian in the Devonian, it's evolving, so please feel free to give me any feedback that you have, because I'm still thinking through a number of these issues. So very excited to be here. And now I'd like to force you all to listen to a story from my childhood. I grew up in the rural outskirts of Memphis, Tennessee, and in the mid-90s, it was very common to hear and see red-headed woodpeckers in the woods of my backyard. So much so that I kind of took it for granted. But over time, that changed. And by the time I was in high school, it was actually quite rare to see a red-headed woodpecker. Now, red-headed woodpeckers are not federally listed as endangered. They're not even endangered in Western Tennessee. There just were appreciably fewer of them in a way that struck me as a loss then and strikes me as a loss now. And it turns out what I observed with red-headed woodpeckers might have been part of a bigger trend. In 2019, scientists published this study in Nature, Science rather, reporting that the US and Canada since 1970 has lost 3 billion birds. That number is striking in itself, but beyond that, what surprised the scientists was that the kinds of losses were not being incurred in the birds we typically think of as more vulnerable. So your raptors and your waterfowl, typically the birds that we've thought of as being greater conservation concern over the years. Instead, the bulk of the losses happened among birds we think of as common. So finches, swallows, sparrows, warblers. Once again, the scientists weren't claiming that these birds were on the edge of extinction. They were just pointing out that we had much fewer of them than we used to, than we did about 50 years ago. And what's true for birds seems to be true across the animal kingdom. So even if we stave off extinction, ours is a world with fewer feathers and fireflies than that of our grandparents or even our parents. Over the past couple decades, we've lost about 30% of the insect population, we think. Each year in the United States, we lose about 4% of amphibians. And so this is a problem that's spread across different kinds of animals and seems to have a lot of different kinds of causes. In the case of birds, it seems to be related to a number of different issues, including pesticides, plastics, habitat destruction, etc. So because scientists are just now grappling with the magnitude of these kinds of losses, it's not something that legal scholars have thought about that much as a distinct problem from extinction risk. And that's why I want to talk to you about it today. So for the rest of this talk, I'm going to lay out sort of 3 different parts. The first is I just want to explain how this came to be in the first place. How did this happen that a country replete with environmental laws and regulations failed to detect and prevent these kinds of major losses of wild animals? Part 1. And part 2, I'm going to argue that policymakers should care about the loss of wildlife abundance. I'm not going to do this from the ground up, from first principles. Instead, I'm going to argue that a lot of the goals that environmental statutes purport to care about will be thwarted if we fail to consider and protect wild animal abundance. And then the third part of the talk will just gesture towards some possible legal reforms. That's going to depend to some degree on which goals one prioritizes, though I will talk about some points of convergence as well. Before we move on, I just want to say, because red-headed woodpeckers were somewhat influential in my writing of this piece, I asked AI to generate a picture of a red-headed woodpecker as Virgil in Dante's Inferno. And let me tell you, worth every bit of water and energy it took to produce. Okay, so part 1, how did this happen? How did we end up in this situation? We know we have all these environmental laws and regulations. We hear about it all the time. Well, the fact is that no particular law squarely addresses abundance across animal species more or less inclusively. So, of course, we have statutes such as the Endangered Species Act, but those are just concerned with species that are dwindling, that are pretty rare, rare or threatened species. So if you're not rare or threatened, if you're common, the Endangered Species Act isn't going to necessarily pick up on major declines in your population. Then we have other statutes that protect particular populations that we value for some reason or another. So we might include in that state game laws, which are laws by states regulating whether, how, what means we can kill game animals because we care about them. We want to keep them around so we can shoot them. And then the Marine Mammal Protection Act, which protects, of course, marine mammals. So these are laws that protect animals, but they only protect certain subsets of species. Then finally, we have over here geographically based protections, and I'll add to this kind of permitting based protections. So wildlife refuges, national parks, conservation easements. These are protections that cover a wide range of animals, but usually constrained to a particular geographic area. So park will protect animals if they are inside the park, but not necessarily if they leave the park. And permitting requirements also can protect a wide variety of animals, but the kicker there is that it's not always clear that a decline in a common population is something that should be considered significant or in any depth by a permitting authority. So even if a permitting authority has the discretion, say, under the National Environmental Policy Act, to think about the effects of a given action on, say, red-headed woodpeckers, that's not necessarily something they have to think about that much or take very seriously. So one might ask, well, does any of this matter? Maybe the laws got it exactly right. Maybe we should really only care about animals that are about to go extinct and whatever subset of animals we care about for other distinct reasons. I think that we should care about animal abundance if we care about the goals that we allegedly are striving toward with different environmental statutes. That is, I believe that the goals and interests that certain statutes on the books purport to protect are imperiled by losing animal abundance. So first, I have human interests. I think there are a variety of human interests that are implicated by losing wild animals, and I'll go into them in a little more detail in a bit. economic value. I have that in quotations because, as anyone who's familiar with cost-benefit analysis knows, we can make almost anything an economic value. I here am envisioning things that go really toward the bottom line of, say, a municipality or an industry interest in a fairly direct way, but I recognize that other things could be put in economic terms. Cultural value and aesthetic value. So these are things that are pretty embedded in our law currently, but which I think are going to be threatened if we lose wild animal abundance. Then we have ecocentric interests, which I'll go into more in a bit, and animal interests. And I talk about them not so much because they're very embedded in environmental law today in the United States, but more because they're part of legal movements that might be gaining some traction. And, you know, there are hints of these values in the law as it stands. All right, so human interests. Well, we have a few possible ways of thinking about animal value for humans. So one is just economic value, extractive uses such as hunting, fishing. You know, if you take an animal out of the wilderness and use it in some way. Then more reusable, kind of recreational, touristic interests. And then ecological services. And so these are the things that animals provide that are indirectly very beneficial to us, whether that be pollination or nutrient cycling. There was a pretty interesting article in Science actually this past fall about how the loss of bats due to white nose syndrome often presaged the increased mortality among infants later. The link there being hypothesized to be increase in pesticide use actually by farmers in these districts. So economic interests, then cultural interests. Certain animals we associate with particular kinds of points of pride nationally, or alternatively, tribal interests might consider particular kinds of animals to be especially culturally significant. And then we have aesthetic interests. And here I have in mind, you know, just that people enjoy encountering animals in their daily lives, and then maybe also seeing particularly impressive or dramatic phenomena of wildlife. Okay, so how are these interests harmed by losing wildlife? Well, if you lose wildlife, you can't rely as much on different services like pollination, like nutrient cycling. You can't be as sure that you're going to be able to engage in the kinds of cultural interests that you hope to. And not only might you just see fewer animals in your daily life, but you also might not be able to see some of the great migrations that people like to see, or big flocks of animals. So your aesthetic interests might be harmed as well. And the law allegedly cares about these kinds of interests. So several laws, for example, the Federal Land Policy and Management Act, FLPMA as it's called, sets forth concern about managing federal lands so as to ensure that they are realizing natural resources and economic returns for generations. Also, the Office of Information and Regulatory Affairs has sought to put economic value on ecosystem services. So these are economic interests that the law tends to recognize and care about, and would presumably be concerned about if wild animal abundance began to drain away that value. Similarly, the Wild Free Roaming Horses and Burros Act protects wild horses as symbols of the pioneer West. So again, allegedly caring about sort of cultural interest in animals. And then aesthetically, there's once again the Federal Land Management Policy Control Act and the Forest Service also have these mandates to consider and protect the scenic value of the areas that they manage. And also the Endangered Species Act purports to protect endangered species for a variety of reasons, including aesthetic, ecological, educational, historical, recreational, and scientific. So these are all interests that are present in the law today and would seem to be harmed if wild animal abundance declines in meaningful ways, even short of extinction. Okay, ecocentric interests. So ecocentric interests here, it's just the idea that the environment might matter for its own sake. And I suggest that there are at least two ways to think about this. One is the idea that just biodiversity matters sort of for biodiversity's sake. Often when you talk to conservation biologists, they sort of implicitly embrace a sort of ethic along these lines, that we just shouldn't allow species to go extinct because they're species and there's something bad about allowing species to go extinct. Similarly, for ecosystems and nature, there are some views that hold that ecosystems and nature, for example, a river or a lake or nature itself, has some kind of inherent value, and it is wrong to harm that inherent value. This has been particularly popular in the international rights of nature movement, which is very tied to indigenous beliefs. Doesn't have as much traction, I would say, in the United States, but is very much something that people think about and talk about. As for this one, I would say that it has some purchase actually in the way the Endangered Species Act cashes out. So even though the Endangered Species Act's purpose claims that it is protecting species for human interests, the way it tends to be implemented, it just protects all species. And it's not an argument that you can make to say, well, I don't think the species is particularly useful or pretty, therefore it doesn't matter whether or not we protect it. So purpose is definitely human-based for the ESA, but in reality it ends up often kind of being protecting species for species' sake. So how does it matter if wild animal abundance diminishes meaningfully to these interests? Well, having more animals is just a prophylactic against extinction concerns. So if you are concerned about the extinction of species, you also ought to be concerned about the earlier depletion of species as a means of protecting from getting to a point where a species might be on the brink of extinction. For this more nature-based approach, it kind of depends. There's a lot of different ways of defining what level of nature you're protecting, what kind of rights you're observing in that nature. But certainly one view would be something along the lines of, every animal or species within a given ecosystem having some kind of inherent value, and therefore it being a harm to nature or an injury to nature in some way to allow a major part of that population to diminish significantly. And last, we have animal interests. So as many in this room are probably aware, of course, the animal advocacy movement has really blossomed since the 1970s. There are multiple ways to think about animal interests, of animals having inherent value individually. Some people think of it through a rights-based approach. Some people think of it through a welfare-based approach. But the basic gist is that a lot of, maybe most of, individual animals have some kind of moral standing based on their inherent value. And this is, again, less embedded in the American law in the wildlife context than human-based interests are, for sure. However, there are some anti-cruelty laws. The Prevention of Animal Cruelty and Torture Act applies to wild animals that suggests that we do, in fact, recognize or care to some degree about harms inflicted on individual wild animals and recognize some kind of moral standing on the part of animals. And losing animal abundance could affect those individual interests of animals. So for one thing, it can interfere with ALE effects, or effects that are particular kinds of behaviors that animals need to group together in order to behave in that way. So here we see a lot of penguins huddling together. This is very important for their survival. And of course, if you take away penguins more and more, then you interfere with this critical behavior that they have. So there are a number of kind of social behaviors like that losing animal abundance can interfere with. It's harder to find mates, for example. I will note slightly more provocatively that maybe you could also say that it's a harm to individual animals to cause their premature death. There are reasons that's sort of provocative, which I'm happy to talk about in the Q&A, but I'll just put it out there as a potential thing that some people might think, that it's wrong for individual wild animals to be killed before their time. All right, so given that animal abundance implicates goals we care about, then the question is, what, if anything, can we do about it? And I'll talk about this in two steps. First, I'll talk about which animals should be protected, and then I'll talk about which types of legislative or regulatory reforms make sense. All right, so which animals are protected? Probably while I was talking, you were thinking, Natalie, this all sounds great. These are, there's something here for everybody. There's probably at least one reason to protect animal abundance that kind of resonated with you. But don't they conflict with each other? And aren't we going to have to make decisions about which kind of framework we adopt? Because that will determine which animals need to be protected. And the short answer is absolutely. Not any one of these given frameworks isn't necessarily going to protect all animals, and it's not necessarily going to protect all of the same animals. However, there is sort of a point of convergence here. So for human-based interests, that's going to cover useful animals, and then animals they rely on. Useful here I'm defining pretty broadly, though. Like, useful would include animals that you like to watch from your window. So if you like to watch birds at the bird feeder, that would be a useful animal insofar as you enjoy the aesthetic value of the birds. But still, at the end of the day, a human-based approach is only going to support protecting animals that are in some way enriching or important to human health and welfare. Then we have the rights of nature approach. Again, this one's a little more difficult and kind of depends on what level of nature you're saying has certain interests or rights, but it seems that you could certainly define a sort of nature-based approach as protecting virtually all native wild animals, applying to all of the animals within a given ecosystem, or just applying to all species because you care about species. So that's that one. And then for animal interests over here, well, this would involve protecting animals that you say have moral standing, and that might depend on sentience, it might depend on autonomy or agency. Different people describe it and defend it different ways. But you're going to want to protect whatever animals you define have moral standing and the animals they rely upon. Now, these are definitely different categories, but I note that probably the upshot here is that under any of these frameworks, you end up having to protect a lot of animals, because even if you're only protecting ones that are useful to you, well, you're probably going to need to protect the various animals that they rely upon within their ecological network. Similarly with animals that have moral standing. I mean, there could be a world in the future where maybe we can provide a lot of the services they need through artificial means, but we're probably not there yet. So one upshot here is probably whatever kinds of reforms we think about are going to have to be sort of broadly targeted, and it will be more an exercise of snipping away particular animals that don't matter for whatever framework we're thinking about, rather than going piece by piece and adding animals in an enumerated kind of way. All right, so bear with me. This is kind of the last big chart, thinking through possible reforms. And I guess I'll start by saying I laid this out as potential legislative reforms and regulatory reforms. I did this thinking of legislative as not being only federal, but also potentially at the state level. And then regulatory, I set out, the reason I broke it up like this is for the situation where you might not have any legislation forthcoming, kinds of changes that could be easier to implement just based on regulation. So there's that. And then I'll also note that for legislative, I divided it up between procedural and substantive reforms. There's a reason I did this. When I first thought about this problem, I thought, geez, we're dealing with a ton of different animals in a ton of different circumstances, facing different kinds of risks. That sounds like something where we should have a kind of procedural element to to our reform or protection, just because we tend to think of procedures as being kind of flexible, able to take into account the given circumstances on a case-by-case basis, not binding us to any particular decision that we have to make every time. So there is some appeal to procedure. On the other hand, I actually think that procedure, and I suppose this is sort of a common theme more broadly right now in environmental law generally, it's not always the most efficient. You can sometimes end up slowing down projects that would, on the whole, be more helpful to the goals you're trying to advance. And you can end up sort of reinventing the wheel. If there's a particular kind of substantive reform that is good and works most of the time, why not just have a substantive reform? So I think the takeaway here, as I'll go through these options briefly, is that there are a number of different possible reforms, and you can kind of tailor them as you see fit. So up to this point, I haven't really talked about other kinds of interests that you might have completely apart from whatever environmental goals you want to fulfill. But of course, society cares about other kinds of things besides just protecting wild animals or just protecting the environment. And I suggest that if you want to make something, say, more palatable politically, you can always narrow or broaden the particular reform that you're thinking about adopting. So we have at the top a sort of National Animal Policy Act that would be like the National Environmental Policy Act, but for animals, specifically targeted at animals. One could appoint representatives of animal interests in decision-making processes. One could give standing to nature or individual animals. This has already, of course, been something that's been litigated more among captive animals in the United States, thus far unsuccessfully. One could recognize human rights to animal abundance, recognize rights of nature or animals to abundance, prohibit or discourage harming declining populations before they become threatened, which would essentially be like a baseline shifting of the ESA to some degree. Require or incentivize measures that decrease deaths, such as bird-safe glass, fund or approve large-scale positive interventions like wildlife crossings, captive breeding programs, incorporate wild animal instrumental value into CBA, incorporate wild animal welfare into CBA cost-benefit analysis. You could have a deeper analyses of effects to wildlife in NEPA analyses, or you could have more small positive interventions in nature, e.g. guzzlers. And what I mean by guzzlers are those are in a lot of areas that are publicly managed in the West already, where water is scarce, agencies have just dug kind of little wells that well up with water that wild animals can come and drink from. So sort of small scale interventions that tend to make life a little bit less difficult for a wild animal in the wild, but not anything as major as, say, in California. There's right now a really big multi-year project to create a wildlife overpass over a major highway, which would be something that would not be something an agency could probably just unilaterally do on its own. And then here I've marked what frameworks or interests each of these seems to sort of line up with. And when I was doing this, I'll say I wasn't necessarily thinking that any of these would be completely prohibited per se by another interest. Is more, would it be consistent with that interest if that interest were the sole thing you were thinking about or prioritizing? So in some ways, this understates the overlap among interests, because I think most people, for example, who embrace some kind of animal interests would also acknowledge some human interests. And therefore, even if a particular reform doesn't make sense under someone who solely thinks about animals' inherent value, they might end up making sense when combined with, say, human interests that they care about as well. There are lots of question marks, and those question marks to some degree depend on how you define one of these interests. So a theme that's been repeated throughout this talk is that for ecocentric interests, it kind of depends on how you define the given level of nature that you care about and how you define a harm to that type of nature. So for example, just requiring or incentivizing monitoring, there's no reason that I think humans in particular would have an objection to that. But depending on your view about the dignity of nature or what constitutes a harm, maybe some people would find that a kind of violation if you put in a lot of trap cameras or bio-tracking devices, as is increasingly being done. And then from an animal interest, one probably wouldn't necessarily care about it from a welfare standpoint, assuming that the means of monitoring the animal wasn't harmful or didn't hurt them in some way. On the other hand, if you're more of a rights-based person for animals, you might think that they have some kind of right to privacy. So maybe you wouldn't be cool with any kind of monitoring. It depends. But I think the takeaway here is that there are several areas of possible convergence for these different kinds of reform. A number of them are procedural ones, and so those might run into outside kinds of concerns, based on just like political will or concern about introducing more procedure into building processes. So you could either craft them more narrowly or just choose to sort of forego them for now and choose some of the other possible reforms. But there are some reforms that are substantive and seem to be the kind of thing that everyone could get on board with. So, for example, requiring or incentivizing bird-safe glass. Especially, there have been cost analyses that suggest that in big commercial-sized buildings, adding bird-safe glass can be a pretty small additional cost and can be really effective at saving bird lives. So, what I want you all to take away from this talk is that although there are points of disagreement and divergence among these different kinds of interests, there are also some areas of convergence that we could start implementing really quickly without necessarily all aligning as a society on exactly why we care about animal abundance. And with that, on a somewhat hopeful note, I look forward to your questions.